attorney, Michael Barnes, also has expertise, drug policy advisor here, so providing unique expertise for us. Michael, we're getting ready here for Dr. Schaefer. He is the crescendo, the final witness for the prosecutors here. And Lauren and I have been talking about what does the prosecution need out of him? What do you want to hear from him to slam the door for the prosecutors?
Well, Mike, I have to say I couldn't disagree more strongly with Lauren's analysis, because I actually think that it's this combination of drugs, and I think the experts have already indicated that they agree with me, that has made this circumstance so egregious. And the experts have also said that even if Michael Jackson had self-administered propofol, the Dr. Conrad Murray would still be criminally responsible, as well as responsible under the standard medical care for the death of Michael Jackson. So it doesn't matter. We need to get back to the big picture and look at the probable result of leaving an individual who is drug seeking in the room full of very strong medications and controlled substances is overdose. And that is enough for causation. If the probable result of the action is overdose, and overdose occurred, then you've got causation. Okay.
And by the way, I want to let everybody know you're not going to miss a moment of the court proceedings. We'll get you to Los Angeles as soon as things begin. Guys, want to take a break? Okay, let's take a quick break. There's the Great Seal of the state of California, and only would have put Michael Jackson to sleep for 3 to 5 minutes. So he keeps sleeping. 20 minutes later, Dr. Murray's thinking the propofol's out of his system. He's safely sleeping now. I'm good to go to leave the room. Don't you think that's going to be that example, something that they're trying to teach a jury and give them a reasonable doubt nugget to hang on to?
I actually think that that issue is the biggest one for the prosecution's benefit, because basically what we've learned from these experts is that Dr. Conrad Murray didn't know the difference between someone who had overdosed and was in the process of dying or dead and someone who was sleeping, or, depending on the defense strategy, someone who was playing possum. And if Dr. Conrad couldn't tell the difference between those two, or didn't know to check for the difference between those two, then he in and of those activities in and of themselves was engaging in inherently dangerous activities without the due caution, and you've got the primary elements then of the crime of involuntary manslaughter. You add in the causation, and Lauren and I just frankly disagree, probably based on our differing perspectives, but I think that there's no way to get around the notion that if you put a drug seeker in the presence of these dangerous medications, that the probable result is going to be overdose.
Okay, just getting word from court, by the way, one of our producers, Jim Kyle, letting us know that the judge is ruling on an evidentiary matter in the courtroom, so proceedings could begin any moment now. Well, guys, we've talked a lot about, and I love the debate back and forth. That's where HLN News and Views. We want everybody's view on this as we watch this case. Credentials. Bring in Michael Barnes, again, attorney and also drug policy advisor. So this is, Michael, this is down Broadway for you, your area of expertise, all the articles he's written, he's a speaker and all that. So we've established that. Key, I thought, Michael, I'm going to get your take on it, what he just said, cutting both ways, because he talked about he doesn't charge for medical malpractice. He doesn't want to profit from medical misadventure. I got to think the defense likes that terminology. Didn't refer to this as, and he wasn't talking about specifically to this case, but he used that terminology. And I got to think the defense likes that.
Well, medical misadventure fully describes what Conrad Murray was on. I mean, he was out doing things that no one else does. He was off on a path entirely by his own. So I don't see what the benefit to the defense is with that. Mike, what were you thinking?
Well, just that... It's a lighter way to describe it, is what I'm saying.
Yes,
I think that the defense would like this to be a medical malpractice case as opposed to criminal involuntary manslaughter. And I think anytime you get that out there, that's good. Now, is this going to decide the case? No, but I was surprised to hear him say that. I think what was more really important to what he had to say was when he just blasted away saying patients are asking him, are you giving me the drug that killed Michael Jackson? And bottom line, when this is done safely, by people who know what they're doing, you're okay. And that's what the prosecution wants.
That's one of the key messages that people who I work with in the field of prescription drug abuse prevention and treatment always convey, which is that medications are safe when they are used as directed. And in this case, we're seeing that when they're not used as directed, it's really possible, it's extremely likely that there will be an overdose. And that's, of course, why we were getting to the point of probable cause earlier. But I also thought it was really important that the doctor already said that he's here because he wants to basically protect the names of physicians, that not all physicians are bad, and that, you know, this drug is not going to kill you.
Okay, we'll listen to some of that testimony coming up in just a little bit. HLN, the place to be, and we'll get back to court in just a moment. Stay with us. The person administering knows what they're talking about, knows what they're doing. Let's listen to that.
I would like, hopefully from my testimony in part, for people to understand that when they are given these drugs by people who know what they're doing, they're good drugs, they can be safely given, and that what has happened in this case has nothing to do with their experience when they see a doctor for a procedure.
Okay, there you have it. Michael Barnes with us, attorney and drug policy advisor. So again, this is right down Michael's area of expertise. Michael, again, that's what we were talking about, and that's what the jury's hearing, because this guy, very credible. He's teaching the jury as he goes, and here he's saying, yeah, part of the reason I'm here is because of what Conrad Murray did.
Yes, this trial has huge implications for the medical field and the prescription drug abuse prevention and treatment communities. Prescription drug abuse has actually been labeled an epidemic in the United States by the CDC. I don't know if a lot of people are aware of that, but the big issue that can come out of this case is it can draw attention to the need for prescribers to get very good education, to be very confident in prescribing, to make sure that they are prescribing in the right quantities and the right doses, not giving too many doses, counseling their patients to make sure that the patients are not selling them or selling the medications or giving away the medications. All of this can really drive a lot of attention to the issue for prescriber education and safety around medications if indeed Conrad Murray is found guilty. If he's not, I'm very concerned. Okay,
so you're saying this has huge ramifications to just patients like you or I, to make sure that people who are administering this stuff are indeed qualified, and we all know it.
It does, and that's what Dr. Schaefer was saying. He said that on a daily basis, when he practices anesthesia, people are saying, are you giving me the drug that killed Michael Jackson? They're very concerned because the medication, when used improperly by somebody like Conrad Murray, is dangerous. But when it's used appropriately by the experts that we've heard from, it's very safe, and there are very rarely any adverse consequences. So this affects the patients as well as the prescribers, their need for education, and everyone's need for improved knowledge about prescription medications and how to be safe.
Got it. Hey, that's big picture. Getting back to this case, what is the one point you need to hear from him if you're a prosecutor?
I'm so glad you asked, because the point that, to me, is still unclear from the facts is what was the deal with the bottle in the bag? If indeed there were a propofol bottle in the saline bag, what does that mean? We have to know that in order to know why in the world the prosecution and defense were going after that medical examiner about the bottle in the bag.
Isn't that is so key? I mean, because we had the security guard, Alberto Alvarez, say he saw it, but we don't have the picture. The coroner's investigator, Elisa Fleek, did not take a photo of the propofol bottle in the bag, but we have two people that said they saw it. Man, that is key, because we want from this guy, from Dr. Schaefer, to say whether or not that's appropriate, whether or not that's possible, all of that, so the jury has a clear understanding, and you and I as well. Michael, you and I will continue in a moment. Want to let you know court will resume any moment now. You're not going to miss a moment of key testimony from the... Hey, what was your reaction seeing it, Alan? And how do you think a juror's going to take it?
Well, I think the jury will be left with an impression that this may be what it looked like, at least when Michael Jackson died. But what actually didn't happen, I guess you could say, what didn't happen when Michael Jackson died, there wasn't a surgical staff there. They didn't have the devices to open the airways, the devices to monitor him, to defib him, and all of those other things that they show in the cardiac arrest video. And that is the impression that they will be left with, that this is the way it's done, not the way the prosecution says Dr. Murray administered propofol, and that eventually led to the death of Michael Jackson.
Well, we have said, and I thought we might get some kind of demonstration. I didn't think it'd be in video form. Let's get our attorneys weighing in on this one. Michael Barnes, I'll start with you. That's going to be powerful for a jury to see what, as Alan put it, what should have happened from start to finish, and even what should have happened in case of emergency.
Yes, and as I mentioned, I hope also we'll be able to see the details of what that makeshift IV drip was with the bottle in the bag. But I was going to say earlier, and I tweeted that it's a good thing we're going to see a dramatic video, because Dr. Schaefer is such a good anesthesiologist that he can put people to sleep just by talking. So I'm happy to know that there's going to be what the defense has labeled an overly dramatic video.
Gotcha. Hey, do you think the defense has a good argument, Michael? I know where you're coming from. You want to see it, and you want to let the jury decide for themselves. But what do you think of the defense's argument? It's too dramatic, and it's I believe, terrifying dramatization is some of the terminology they're using.
Well, I mean, I guess it kind of makes sense when you consider that there was no action on Conrad Murray's part. He didn't do anything to revive Michael Jackson. And so when you show any doctor in a video dramatizing attempts to revive a patient, then it's an over-dramatization, right? Because Conrad Murray was on the phone with his girlfriends and his other patients.
You were waiting for that, weren't you, Michael? You were all over that one. Hey, Alan, on a serious note, when you talk about this kind of a video that could be so impactful, what about members of the Michael Jackson's family? Are they there, and do you expect them to stay and watch this?
Yes, they will. They've seen it. They saw it this morning when the judge first saw it. Catherine and Joe, Reby and Randy sitting there on the second row of court. Yeah, they saw it, and they were watching very closely, paying very close attention to it.
Any reaction that you could see, Alan, upset them at all, or they just intently watched?
You know, I did. They were talking amongst themselves. I saw some disgust, I think, on their faces, like shaking their heads a little bit about, so this is what it should have looked like. I think that's what I read on the faces as I did try to watch them. You
know, and Michael Barnes, it's an old cliche, but it's so true. A picture's worth 1,000 words. You can have expert after expert, but if you let a jury see again, what the prosecution contends should have happened, someone being sedated, how many steps you have to go through, and if there is something that goes wrong, this is what should have happened. All the equipment that would have told you something is desperately wrong with the patient here.
That's right. I think this video is going to help the jury to really visualize what the two other experts have already told the jury about what the standards of care are. And I also think that this video could answer some outstanding questions. In addition to the bottle in the bag, there's the dose and drip. What did the dose and drip really mean, and what impact does it have on the jury's deliberations?
How much has this been a concern for you, Michael, that the jury doesn't get it, maybe like you and I get it because we've been seeing it and we're watching it from outside? We're not in that jury bubble.
I definitely agree with you based on facts that the jury doesn't have everything to put together the case, not for the prosecution or for the defense quite yet. I do think the prosecution has what it needs, if it gets a little bit more from Dr. Schaefer, as we mentioned, to be able to put together the facts that have come out into a story that tells the jurors exactly what occurred and why it was a crime. So we've got everything. They've just got to wrap it up and put it together. And then the defense has got to come back and create some whole new story.
Gotcha. Well, speaking of defense, let's bring back criminal defense attorney Lauren Lake. Lauren, we've been talking about a video that's about to be shown. The defense does not like it. They're saying it's, I believe the terminology here is a terrifying dramatization. It's going to show, it's a silent video, and Alan Dukes laid it out there, but what should have happened if someone's being sedated on propofol, and what should have happened in case of emergency? How powerful do you think that's going to be for a jury to see?
Well, video is always powerful. I mean, let's face it, we are a nation that loves to watch television reenactments, and we're a CSI culture. We want to see a reenactment. We want to see how did it really happen and give us a video to look at. And it can be inflammatory, and I think that's what the defense's issue is.
How do you argue that? And that is the terminology. Extremely prejudicial, terrifying dramatization. Is it a good argument, or they're just frightened what a jury might think of this?
Well, let's be honest, defense attorneys are still human. We're not crazy. I mean, if something is going to really affect the jury and it's going to, affect our client's case, we have to argue vigorously that we've got enough evidence in place here. There's no reason to bring this video on that's going to completely inflame the jury. The fact that they're going to remember this visual aid versus be able to just synthesize their facts, and because they are the trier of fact. In a way, this video kind of will probably sum up everything in a sense. And I think the defense is going to argue, no, the jury is responsible for summing up everything, and don't give them this video that they can take home and remember in their minds over and over again, and then that may therefore decrease their chances of kind of synthesizing the facts on their own. The defense has to do what it's got to do at the point. Let's be honest. There's been a lot of evidence.